Well, I'm sure you've seen a few of the snippets there, but yes, I mean, there was stuff on COVID-19 and also stuff on the Electoral Act, and the Electoral Act continues to loom large. It was the last thing that was considered before the National Assembly went on recess for this holidays. And they've certainly given us something to chew on and, you know, decide whether or not we're happy with in terms of what they've passed, even though in some instances it's not very clear what one of the chambers did because of the rancor that had, you know, that had, I don't want to say clouded, but for want of a better phrase now, clouded the proceedings on the day that it was supposed to have been passed. Nonetheless, we have two passages now from both the chambers, from the House of Representatives and the Senate. It's causing controversy of some sort, and for some, there are legal implications to what has been passed. For others, they're still dissatisfied, even though they're members of the National Assembly. They're dissatisfied with what has been passed in-house, because don't forget that some people, you know, it's a matter of, it's democracy. It's numbers that eventually carry the day, not because everybody agreed, but because majority had their way. Now, for those who had their say, or, you know, who are dissatisfied, what is going to be the next step for them? We have this morning Mr. Robert Emukwero, who is a senior advocate of Nigeria. He'll be helping us with the legal perspective of things. You're welcome to Sunrise Daily this morning.
Thank you so much for having me.
And we also have Honorable Solomon Bob, who is a member of the subcommittee on INEC. You're welcome to Sunrise Daily as well.
Thank you. It's not like subcommittee on INEC, it's a commission on electoral matters, no subcommittee.
Okay.
But we had a joint House and Senate
joint technical committee, yeah. Yes, which you were a part of.
Yeah, of course.
And you know, which was able to reach the report that eventually was submitted to both chambers for passage.
Sure, sure.
And you can confirm to us, Honourable, that indeed what was laid before members on the floor of both chambers, what was passed, agreed upon, I think, for want of a agreed upon by the Joint Technical Committee. Don't forget that there had been fears that the report was tampered with or could have been tampered with before it was laid. Can you confirm that what was laid to both chambers was what was agreed upon by the Joint Technical Committee?
Yeah, thank you. I think it's a good opportunity now that the whole issue has blown out in public space. So basically put in context what actually happened. It was the Senate that attempted to corrupt its own version of the report. Our report was intact. What we did, the work we did in the Joint House and Senate Committee, the House's version was intact. Nothing was done to insert anything or basically, try to thwart what the committee, Joint Committee, did. It was the Senate that tried to insert that in their own provision. Okay, that was found out, and then I think eventually tried to beat the retreat. But we'll get to the point, of basically trying to understand what really happened. But this is just the context that led to what you're talking about. The House's own report was intact. Nothing was done about it. What we laid was what the committee recommended. And that recommendation was, the efforts of a compromise, because some of us wanted more than that, but there was serious pushback by those who didn't want anything at all to do with transmission electronically in the law. Okay, so we came to a point where we could get a minimalist view, or a position rather, to achieve what we laid on the floor. So what we laid on the floor was what the committee, Joint House and Senate Committee, recommended. For the House, Senate's own version was, as I said, a completely different story. Okay, and their own was, it seemed like a deliberate ploy, to take back everything, and leave the bare bones.
Well, it looks like on the floor of the Senate, I do know that a day before that report was laid, even though it took a while, the Speaker of the House had come out way before that time to say that, look, the report that was given to him has not been tampered with. It's still with the leadership of the House, and, it was safe. It took maybe another week before the Senate President came out to say the same thing about the report that was, also given to the leadership of the Senate. But eventually he did, to say that, nothing, the report had not been tampered with and it was going to be laid eventually. I think a day before the bill was eventually considered.
Well, the Senate President position was incorrect. I can say that it was incorrect. We were given documents, they tried to pass on documents to us from the Senate, with a view to also incorporating into our reports what the Senate had done. We refused. We had a meeting the day before. I was on one of your sister programs on, I think it was Politics Today, where I maintained that the House's position with respect to the bill we had passed was intact, and that if there was any extraneous material, it couldn't be linked to the House. But it's a different thing altogether what transpired on Thursday and Friday proceeding. Okay, but with respect to the position of both House leadership in terms of what was before them, before they were laid, I think that the House's position reflects exactly what we did. The Senate only didn't, but it's an attempt later to, basically try to, undo some of the harm that had been done because of the blowback, the public outreach at what had happened.
Mm. Well, eventually the reports were laid before both chambers, and we saw that in the House, in the process of passage, there was plenty of rancor, there was plenty of heat. And even at some point, it was members came to fisticuffs. And it was not successfully passed on Thursday when they thought the House was going to go on recess after the passage. And it had to be moved to Friday. Even at that, we saw members of the PDP stage a walkout as a result of their dissatisfaction with the process. To your mind, I don't know if you can quickly bring us up to speed. I will come to you shortly, Senator. I beg your pardon, Mr. Mukbero. Can you quickly bring us up to speed as to what led to arguments getting so heated? If you say that what you were able to agree upon was a minimalist position that was, it would seem, already well thought out by both chambers, the Senate committee and the House committee, the joint committee, and still it would seem that it was largely unacceptable to many on the floor of both the House and the Senate.
Yeah, it's unfortunate. You see, we're in a system now today, we have lots of, I'm sorry, but it has to be said, reconstructed ideologues for whom democracy is a mere empty abstraction. They don't believe in tenets, in the practice of it. Yes, what we did was, our position was a minimalist one. But even that, was causing rancor among some certain persons, in the legislature. The sequence of events that followed, or rather the trigger to the sequence of events that followed, you saw on Thursday, was an attempt by a member to basically, dissipate order with it. He came with a motion on the floor, that even the minimalist position was not good enough. We should not accept that. He brought a motion to basically say we should have nothing to do with electronic transmission, which is ridiculous. He said we should resort only to manual transmission, manual counting.
Who's that?
Of course, a member of the opposition, of the ruling APC. The motion was promptly defeated. Following that, the second motion was moved to the effect that even what we had, with basically vest control and discretion, with INEC, that even that, which I described earlier as, the basic minimalist position, a motion was moved, subsequent to that one moved by the other member I mentioned, that we should, in fact, even make that better by having it expressly stated that result transmission should only be by electronic means. Okay? I'm sure the whole saw what happened. Okay, the void vote was taken. It was against those who were against it. It was in favor of those who were proposing that we should expressly state it in the law that the transmission should be only by electronic means. But we saw also a capricious use of the gavel by the then presiding officer, the chairman of the whole, deputy speaker. He ruled against the A's, even though it was clearly that the A's had won it. The second motion was moved again. That seemed to water that down a bit, but no less expressive about what should be in the law. Okay, the A's again had it. He ruled against the A's again. Such an extraordinary and capricious use of the gavel. So this was...
Why wasn't a division called for?
Well, a motion for division was called. He ignored it. He ignored it. Like I said, it was an extraordinary use of abuse, basically, of your position as presiding officer. By our rule, when there's a disagreement between A's and nays, okay, when it's called, you have to divide the house. But they refused. In fact, totally ignored it. Next day, denied that there was no motion at all. But everybody knew. So it was these were the events that led to the pandemic you saw in the house and the disagreements, and a lot of things were said. It was heated up. Members nearly came to a position of like you described as fisticuffs. Yeah, it actually happened. But it was the audacity, the daring, unlawfulness of the action taken by the man presiding, and the near absence of decorum on the part of those who didn't want anything at all to do with transmission on the floor. Like I said, it's unfortunate. It's very sad.
So eventually what was passed, and we'll come to what was passed in the Senate, what was passed in the House? Yes, I know that the PDP, the minority caucus in the House, staged a walkout the following day when it would seem that certain things had not gone their way or they did not agree with the process. Honorable Ndudi Lumelu stated the position of the minority members as to why they walked out, staged their protest. But I'm sure that you must have heard what eventually was passed on the floor of the House. What was passed?
Well, what was passed, what was purported to have been passed was what we laid. I have no information that anything else was done to Section 52, the vexatious Section 52, subsection 2. What was passed was what we laid. Like I said, it wasn't so much a matter of what was before the House. It was a brazen attempt, first, to switch that completely 360 degrees and bring something else that was completely at variance with what the people wanted. Okay?
So the House did eventually pass that electronic transmission was allowed. I mean, that INEC could transmit results electronically. Yeah,
that's the House's version, yeah. Like I said, it vests sole authority on what to do, on INEC, or rather with INEC. Yeah, that's what was passed. That's the information I have now. Like you said properly, we at some point we had to leave because that atmosphere had become, very disagreeable, and some of us felt that what was going on there was a charade, and the chicanery abuse all by those who wanted something different from what Nigerians actually demand, was something we couldn't live with. So we had to leave, and then made our position known to the whole world.
Mm. Yeah. Well, I don't know if the story provides a very good background, but I thought it was important that our viewers understood what transpired, at least in the House, because it was seen that there was some confusion. There was very little clarity at the end of the day when the House went on recess as to what exactly had transpired on the floor because of some of the events that had overshadowed, it would seem, what eventually was passed on the floor of the House. But the Senate zone was pretty clear. What happened on Thursday when a division, when they couldn't agree, or when it would seem that the ayes they were not clear who was getting the voice vote, the senators decided to go for a division, and that set things pretty straight. The section 52, which would seem the most vexatious section in the entire amendment of the Electoral Act, was passed with some amendments, extra amendments, it would seem, not as submitted by the joint committees of the House and the Senate. And we saw that the Senate has said that INEC can transmit electronically with the permission of NCC and also the approval of the National Assembly, and that has caused a bit of controversy. I don't know if you want to quickly weigh in on that before we go to other parts which you think will be able to make significant difference to the Electoral Act as currently is, as currently passed by both chambers of the National Assembly.
Thank you very much for that opportunity to give some of my thoughts on this issue. I think, firstly, what I want to highlight is that the reports of the Joint Technical Committee of the National Assembly, comprising the Senate and the House of Representatives, is a recommendation to the Senate and, of course, to the House of Representatives. It is not as if the Senate or the House of Representatives do not reserve the right to revise that recommendation. It's not as if it's binding on them, because it is the Senate as a body that will pass that recommendation or amend it as it so pleases. That is within their constitutional remit. It's not the committee, either a joint committee or a single committee, that has legislative powers. It is the Senate working in conjunction with the House that is reposed with that constitutional power to pass this law. So I really do not think that what the Senate did in changing what was presented to them on the floor of the House is outside the provisions of the Constitution. It's very much within it. They can do that. They can revise any provision. They can reject it entirely, provided a vote is taken on it. I suspect this is precisely what happened, that Section 52 was revised, and it wasn't in tandem with what was presented. I don't see anything wrong with that per se, legally speaking. And what scenario has now been thrown up really is that there is a Senate version that is not in harmony with the House version, which automatically means there has to be a reconciliation so that we have a harmonized version that both houses can pass as law. I think that is where we are now. Now, the other legal issue that I think this throws up really is the section proposed really either by the Senate or by the House of Representatives. I see it as being something to regulate the powers of INEC. Because each is more or less saying, INEC, you will transmit results of the election electronically, whilst that of the House, from what we have just heard now, gives the discretion solely to INEC to do that. And that of the Senate appears to place some caveats on it, namely the NCC's intervention and that of the National Assembly. I think, properly speaking, within the context of the Constitution, we really need to look at what are the powers of INEC. The powers of INEC are constitutional powers, particularly when you look at paragraph 15 of the 3rd schedule. It says the Independent National Electoral Commission shall have the following powers: to organize, undertake, and supervise elections. So for me, the real question is, when the National Assembly is trying to regulate how INEC organizes, undertakes, and supervises election, is it not more or less encroaching into the constitutional powers of INEC? The Constitution has given INEC the power to organize the election, to undertake it, to supervise it, and conduct it subject to its directions. So that really throws up a very serious, to my mind, constitutional question. If these provisions, either that of the Senate or the House, is passed, can it be said not to be an infraction into the constitutional powers of INEC? Because I honestly believe that the reason why the Constitution has given INEC directly the power to organize, undertake, and supervise all elections to the offices in the Constitution is to give it a form of independence and insulate it completely from any kind of interference. Because an act of the National Assembly that seeks to curtail or interfere with the power given by the Constitution, generally speaking, is held to be null and void. So that is the perspective with which I think both houses needs to look at these provisions.
So we do know that, I mean, yes, indeed, the Constitution does give INEC, pretty wide powers with regards to the conduct of elections. And the Electoral Act is supposed to provide, even in further detail, how these powers will be exercised with regards to conduct of the election. Now, you have also said that that is an attempt to regulate the powers of INEC. Yes. Is that how you're seeing the body of the Electoral Act or the attempt at this particular amendment?
Well, I think to answer that question, we need to look at paragraph 15I that gives the National Assembly powers to provide for other functions that INEC may perform. So when you look at paragraph 15 of the third schedule, part 1, it talks of the powers of INEC to conduct election, register political parties, and then the last subparagraph says, and such other functions as may be conferred on it by the National Assembly. That phrase, other functions, to my personal thinking, it excludes those that have been specifically mentioned. It means the National Assembly itself should not venture into those areas that the Constitution has covered, namely organize, undertake, and supervise. You can't pass any law on it. It's possible to maintain that position that any law you pass that tries to regulate how INEC organizes, undertakes, or supervises an election is likely to be a law that is curtailing, interfering with these very broad powers that the Constitution has given to INEC. And this scenario has played out before. In 2001 Electoral Act, where the National Assembly made some provisions to the Electoral Act, adding to the Constitution itself in respect of matters already covered by the Constitution. And the Supreme Court consistently struck down those provisions. That once the Constitution has covered an area, the National Assembly cannot enact any law on it, because it means that the Constitution has covered the field. So for me, the critical question in my mind is the phrase organize, undertake, and supervise. What does it mean exactly? Because once the court defines the ambit of this to include that, look, this means INEC is given unhindered power to organize this election, whatever way you want to define the word organize, to undertake it, to supervise it. Certainly it means that any other law that now seeks to show how we are going to organize it, how we are going to supervise it, it means we are trying to put some fetters on that power.
So to your mind, would you say that there has been much ado about nothing, especially with this electronic transmission and no electronic transmission, electronic voting, no electronic... It's been a big battle that, had been on way before now. We saw it in the 2015 elections, even when INEC wanted to introduce card readers. Any form of anything electronic, so far so good, has been met with pretty stiff resistance, and there have been attempts to, as you said, regulate it in the Electoral Act. I want you to, shed light on why there has been much ado about electronic, adding electronic anything to the Electoral Act, and whether or not there should have been in the very first instance. But I'll let you do that when we come back from this break. Please stay with us. Mr. Robert Mokwero, who is a senior advocate of Nigeria, and Honorable Solomon Bob, who is a member of the INEC committee in the House of Representatives are our guests this morning. And we're talking about what you just saw there, attempts to make amendments on the Electoral Act and, how matters eventually, transpired. Just before we went on break, you had told us that that's Mr. Imukweru had told us that INEC had pretty wide powers given to it by the Constitution, and almost every attempt we have seen have been attempts to regulate the powers given to INEC as stipulated in the Constitution. Is that correct?
Yes, that's correct.
Now, as I was just asking before we went on break, the big question is, what then is there much to do about the introduction of electronic transmission or electronic voting? What's the big deal?
Well, I think what appears to be at the back, or what is fueling this whole controversy, is really two things. The first one is item 22 on the exclusive legislative list that confers power on the National Assembly to make laws with regard to election to the offices of the President, Vice President, and all other offices under the Constitution. So by item 22 of the exclusive, on the exclusive legislative list, the National Assembly is given powers to pass laws for election. Now, that is on the one hand. Then, on the other hand, there are decisions of the Supreme Court, basically, because you did mention the card reader. And the reaction of the Supreme Court to the introduction of the card readers, I think 2011 election, yes, during the 2011 election and subsequent elections, that since the card reader itself was not contained in the Electoral Act, it couldn't be a basis to challenge the conduct of any election, implicitly suggesting that unless the National Assembly enacts a law with regards to the conduct of the election, then you cannot really rely on guidelines of INEC issued to organize, undertake, and supervise the conduct of the election. But in all those series of cases that the Supreme Court had the opportunity to hear and determine,
it was post-2015, I believe.
Yeah, maybe 2015, very likely 2015, yes. The issue of whether or not these legislations interfered with the very broad powers given to INEC did not arise in those cases. But that, or those cases, those decisions, those judgments of the Supreme Court became like an endorsement of the power of the National Assembly to make law with regard to technology in the conduct of election. Because this is basically what is happening. INEC has the power to conduct election. I don't think there's anybody arguing with INEC about that. But it is now the deployment of technology to conduct the election. That appears to be where the whole controversy is raging, to deploy technology. Now, do you need legislation to back that up? For the deployment of technology to do what you are constitutionally empowered to do? Personally, I don't think so. But the Supreme Court has already given the indication that an act of the National Assembly will be necessary for that. But like I said, those judgments of the Supreme Court, the issue was not agitated whether or not that will not be an infraction of the powers given to INEC itself. So for me, I feel that is a moot point. But the way things are, I'm just basically giving you the background to why this is still a controversy, because it hasn't been settled by the court. What has even been done is to give the indication that yes, you need a law of the National Assembly to enable INEC to deploy technology to conduct the election. I don't think it's desirable that INEC should be able to adopt any technological means to perform any of its functions. There are so many functions INEC is conducting right now in terms of the election that they have deployed technology. They didn't need any act of the National Assembly to do that. Mm-hmm. And I don't think it should be made a condition. Otherwise, it means every time there is a technology or an advancement in technology that will aid the conduct of elections, i.e. aid it in the sense of making it more transparent, more credible, more accountable. I mean, that is the key in any electoral process. It must be accountable. You must have a means to verify whatever result is returned by INEC. If we cannot achieve that, then there's a big problem. So which means if a technology, for example, is developed today that will ensure accountability in the process, you have to go back to the National Assembly to say, well, you need to enact this so that we can do it. I see it as not being very, very desirable, really.
Mm. Well, let's flip this to Lagos now. I know that my colleagues have questions for you, gentlemen.
Yeah, Mr. Mukwero, I mean, listening to what you have said now and given how INEC has conducted elections previously, sometimes they've transmitted some results electronically, as they have said. Is it going to be risky if INEC then says, well, the positions or all the drama in the National Assembly notwithstanding, we will transmit these results electronically? So if someone goes to court, if INEC, all this is, in that realm, if INEC does that and someone goes to court, will there be chances that it may be jeopardized given what you cited about the Supreme Court's decision with regard to the card reader?
I think, of course, there is a serious jeopardy that will arise if that was done. Because, like I said, the indication from the Supreme Court right now is that there has to be a law from the National Assembly to back the deployment of technology in the conduct of the elections. So, if INEC were to go ahead to adopt transmission of results of the election without a provision in the National Assembly, without a provision in the Electoral Act empowering it to so do, then it means that transmission of the results is open to challenge, and there are authorities indicating that the challenge may be upheld. And of course, like I said earlier, the specific issue of whether or not the act of the National Assembly that seeks to regulate how INEC conducts election does not fall within the remit of an area that the Constitution itself has exhaustively covered, to the extent that it precludes any other subordinate legislation from playing in that field at all. That hasn't been resolved by the Supreme Court.
But is that still going to be a challenge, given the fact that the results, the voting would have already been concluded manually, and then they have a manual copy of the results? So if they transmit it within, if they transmit that electronically from one of the locations to the other for the purposes of collation. So if anyone still goes to court based on that, how easy or difficult do you think it would be to prove their case, given the fact that they still have records, manual records of those results that have been transmitted?
I think to answer your question, there's always generally a provision in the electoral laws historically in Nigeria that more or less gives a blanket protection to whatever INEC does that is not in compliance with the provisions of the Electoral Act. It usually goes that, non-compliance with the provisions of the Electoral Act shall not invalidate the conduct of the election unless you are able to demonstrate that that non-compliance has substantially affected the outcome of the election. It's in the current provision, it's in the previous provision. So it's not just enough for any person to show that there has been non-compliance with the provisions of the Electoral Act. You must go further to show that that non-compliance has substantially affected the outcome of the election. So even if the provision either as proposed by the Senate or as proposed by the House is ultimately what is adopted, there is always that provision there that you need to show that the non-compliance has substantially affected the outcome of the election.
It would seem
it's not every irregularity by way of non-compliance that can lead to the invalidation of an election. for election petitioners, the burden on them to establish that an election was null or void or, riddled with corrupt practice, a very, very enormous responsibility. And as a matter of policy, I suspect, the courts are loath to just upturn an election. When you just go and say, well, the act says this and they haven't done it, that's never been a basis for the invalidation of any election.
Well, it would seem like, just as you said earlier, there is a need to unpack those three words: organize, undertake, and supervise. And sincerely, I haven't quite decrypted the word organize, because I'm thinking, if I'm supposed to organize an event, the what to do has been given to me. Then the process of how I do it is supposed to be my discretion, at least from what we have on the pages of the Constitution, Section 15 sub A, as you have described to us. So, in terms of that word organize, undertake, and supervise, do you think there is anywhere in the interpretation that we can find electronic transmission, given the way things are in the world today? I'm asking because I don't know if there is anywhere in the CBN Act or Bofia Act that says that the banks shall use technology to conduct their business.
Well, I think that's the point I made earlier, that there is, strictly speaking, no need to legislate for the use of technology in the exercise of powers that are given to you. But where things stand now with judgment of the Supreme Court, as I said, in relation to the card readers, is that there has to be such a provision. It's not as if the use of or the transmission of, let me not use the word transmission of results, let me just use deployment of technology, because that really is what is the issue: deploying technology, either to transmit results, either to conduct election, either to do just about anything. It's really deploying technology. That is really what is at the heart of this whole controversy. So it's just the broad language used or deployed in the Constitution. Organize means you have the discretion on how you are going to organize it, undertake and supervise. It really basically gives you a form of independence to conduct that election. But I keep on emphasizing, the trend of the decision of the Supreme Court is that there must be a provision in the Electoral Act that will enable INEC to deploy technology, either card reader or any other form of technology, to conduct the election. That is why I believe in this current proposal of the Electoral Act. The card reader has now been incorporated as part and parcel of the process of ensuring that the election is free, fair, transparent, and accountable. Because from the card reader itself right now in the present proposal, it's been made the basis of determining whether or not an election will be invalidated in any polling unit. Where the results exceed what is contained in the card reader, the election is proposed to be declared null and void.
Now, given what we have had over the years, where voter apathy continues to taper down on a scary level, and given the controversies that have surrounded this particular proposition of the members of the National Assembly, before, even now at this stage, even before the concurrence by the two chambers, what would you suggest to the members of the National Assembly in this regard? Because there are those who say that it's because we haven't adequately deployed technology that we haven't been able to have the kind of election that you described the other time, credible elections. And if people feel their votes are not going to count, they're just going to, sit back at home and all of that. And that's why, as we say, we are where we are now. So what would you suggest to the members of the National Assembly as they go for this concurrence meeting in order to be able to make the process credible so that more and more people can come out to vote?
No, thank you very much for that. It's a very important question. I will honestly suggest that the National Assembly should look particularly at that paragraph 15 of the Electoral Act and try to empower INEC more to be able to operate in such a way that it can deploy whatever technology will assure and ensure a free, fair, and credible election. Because like you rightly observed, if the people perceive, rightly or wrongly, that the election is likely not going to be credible or transparent, that is a serious incentive for people to come out to vote. So I honestly believe that the National Assembly should look, during the course of this harmonization, they need to look to work very closely with INEC, as they have done, frankly, during the process of even getting up this Electoral Act. INEC officers were part and parcel of the technical committee that brought up this thing. And like you observed, take into consideration other matters in terms of voter apathy. Anything that will encourage voter apathy should be discouraged. So I think that in keeping with the spirit of the Constitution itself, that gives very, very broad powers to INEC, I think that broadness should be maintained so that INEC should be enabled to deploy whatever technology that comes up at any time that will ensure that elections are free and fair.
Ask Honorable Bob, you know, the rationale behind that walkout that was staged by the opposing members, you know, beginning to raise more questions. There's also thought, having walked out, it just paved the way for the other members to go ahead and smoothly approve all the processes that they wanted. So many thought, members should have stayed in there, make your point to the end, or filibuster the process.
Well, thank you. Before I respond to that, let me just weigh in on the few things Mr. Mokweru has said. The House's position, what the House passed, even in our absence, which I've made reference to here already, is consistent with the test schedule, paragraph 15 of the Constitution. It gives INEC unfettered powers to, you know, deploy whatever method it chooses. That's consistent with, you know, the words using that paragraph 15, organize, undertake, and supervise. So if any of the two chambers has done anything to withdraw INEC's powers, it is the Senate's version. The House's version completely, you know, maintains the integrity of the process, you know, by in no way seeking to hamper or prohibit or in any sense undermine the capacity of INEC to do as it pleases with respect to the method it chooses, you know, organizing elections, okay, or deploying result transmission. That's one. Now, to the other point about having to leave, yeah, it's an acceptable, you know, parliamentary practice when there is a behavior that is inconsistent, you know, with the procedure of your rules. It's all over the world. It's an acceptable practice to work out the way we did. That said, let me also quickly add that some of us will have the view that, you know, we could have taken a second thought about moving out at all, and maybe stalled proceeding the second time we did the previous day. Yeah, but but all that now, it's neither here nor there, because as I indicated in my opening remarks, what the House passed, you know, respect the Electoral Act in our absence on the vexatious or the vexed, the vexed section 52.2 is essentially what the committee in which I served submitted. Okay, so there is no, there is nothing that was done with respect to, you know, that provision that is not consistent with what the committee in which I served it. Okay, that's what I'll say about that. But to the broader question of, INEC's powers being capacious enough to undertake election in any mode decides, I've always said that, yeah, I agree. But, I think a lot of the blame only lies in Mr. Emekwaru's own submission here. The judiciary is responsible for muddying the waters. The judiciary is responsible for muddying the waters. But the one who came up with all sorts of funny judgments, questioning INEC's capacity, to issue guidelines and conduct elections in the way they thought best. Yes, their powers are enormous. They are broad enough to accommodate any of the ways and means they think best to conduct elections. But the judiciary has been, pushing back against INEC, using those powers to actually do what it thinks is best. It's the reaction. The action of the legislature is a reaction to those judgments we've seen from the judiciary.
So how do you think, as we wrap up now, how do you think that both chambers are going to reconcile? Because we know that they have to present a harmonious copy. They have to harmonize and then eventually give a copy to the executive for the president to sign. There are those who are saying if the version that is presented to the president is what the Senate passes, that the president should decline assent if he really wants to, give a legacy to Nigerians. But there is a big hurdle, it would seem, to cross before we get to that point.
Yeah, thank you. That's a useful point to make. You see, everybody seems to think that whatever is done in National Assembly is done and dusted, I should say. But that's not true. However, this is a process. We are only at the beginning, okay, of a two-part process. Nothing gives me any confidence that if we passed anything, that doesn't sit well with the other arm of this government, the executive, that it will be signed. So at the end of the day, we are more like this a will-o'-the-wisp, just chasing, maybe chasing shadows. Nothing gives me, there is no genuine intention, okay, to undertake serious electoral reforms.
But before we get there,
yes,
before we get to the part where the president signs,
yes,
how do you see both chambers, get into a harmonized version? Well,
we'll get to that bridge. We'll cross the bridge and get there. When we get to the conference, every member of the conference committee has one vote. So it will come to a point where, just like we saw in the other act that is now a matter of hot public debate, we'll see how. But my guess is that the Senate will be mindful of the powers donated to INEC under the Constitution and pull back from the dangerous part they are working, which is an attempt to basically circumscribe the operating environment for INEC. So my hope is that they would, at the very minimum, accede with the House's own version.
Are you optimistic about that as well?
Well, I personally would prefer that at least they harmonize this bill in such a way that it doesn't constrain the powers of INEC to conduct the elections. That really is what I think is the most desirable thing.
Do you think it will happen?
I hope so. I honestly speaking don't know, but I think when attention is drawn, as I believe we are trying to do, to the wide powers of INEC and the undesirability of always insisting that before INEC deploys technology, there has to be an amendment to the Act. It's really not very desirable, really. When you look at it in the long run, INEC should be able to embrace whatever technology is existing at any particular time, provided it will ensure that these elections are credibly conducted, transparently, and people can verify it. This is the biggest problem in Nigerian election. They are not open to accounting.
And I think that's what a lot of Nigerians desire. Free, fair, credible, and you've added accountable elections.
You can trace how these results are arrived at.
We're totally out of time, gentlemen. I wish we could go on for a bit more, but we're totally out of time. I have to thank you both for coming on Sunrise Daily. this morning. Mr. Robert Temukwero is a senior advocate of Nigeria, and Honorable Solomon Bob is a member of the INEC committee in the House of Representatives. We'll take a break now. When we come back, we'll have another issue for you, so please don't go away.